Good afternoon or good evening, depending on where you're joining us from. Welcome to Season 5 of ARBinBRIEF. Every 14 days, we invite world-leading arbitration practitioners to discuss the most pressing issues of our field. And today, we are honored to have Laura Yvonne Zielinski, Associated Partner at Noerr, based in Frankfurt, and Rachael O'Grady, Partner at Mayer Brown, based in London. Thank you so much, Laura and Rachel, for joining us today. We all know that you are prominent figures in the field of space arbitration, with Laura co-founding the Space Arbitration Association and Rachel being a co-head of Space and Satellites team of at Mayer Brown. So my first question would be, what originally sparked your interest in space-related disputes?
Shall I jump in first? Yes, so I'm an arbitration practitioner by background, and about 17 years ago now, my first space-related arbitration fell onto my desk when I was an associate, and it was an ICC commercial arbitration arising out of a launch contract that had gone very badly wrong. The launch vehicle had actually partly exploded, which is never ideal, and that had related in the commercial dispute that then ended up in the arbitration that we were handling. And I think I was just struck by, I guess space is relatable to everybody, right? So it's a kind of an instant topic that sparks interest. But so that in itself, is a really interesting dispute to do. But also because I do international investment law as well and public international law, I was interested to kind of connect the dots between the two. And although this was a commercial case, it started getting me thinking about, well, hang on, how would this work in, if it were in a public international law context? And it kind of triggered an interest, and which then turned into a bit of a passion for kind of international space law, which I've since sort of written about and spoken about and taught on, and it's just sort of grown from there. So that was my first introduction to it, and why I then fell into it head over heels.
Fantastic. And what about you, Laura?
Yeah, like Rachel, I also started being interested in arbitration in the space sector through a case I had the pleasure of working on for several years. It was an investment case of a French company against the government of Mexico related to the use of geostationary orbital positions. And like Rachel, I have a background in international arbitration and in public international law, and I had worked on cases relating to the law of the sea before. And there are a lot of parallels, at least in the establishment between the law of the sea and international space law. So I found this very interesting. And then during the pandemic, I had more free time, and I did an online course at McGill University on strategic space law and started to read more and more about it, and then also started to speak about it. And speaking for both of us, we were lucky in that the space industry is also growing quickly. So it's a good field to be interested in, because you kind of learn more and more as the industry also develops.
Coming precisely to the current landscape and the recent developments in the field, what kind of space-related disputes are you already seeing in your practice?
So in my practice, starting from that very initial case that I just spoke about, we've seen a huge growth, not an instant growth, but a steady growth over the years of space-related disputes and space-related arbitration, because of many of the disputes don't actually end up in arbitration. Lots of them settle for reasons which we may come on to. But I've seen the disputes that we handle now kind of arise from all ends of the space economy spectrum, let's say. So we have upstream disputes from sort of launch agreements and satellite manufacturer agreements to kind of midstream disputes where things are happening to a satellite when it's in orbit. So an antenna might break, or it might, a part of the satellite might be damaged that then affects the service that it's contracted to give. So then the downstream disputes in terms of kind of the provision of the data that is being derived from space, or the other services that are being derived from space. So we kind of see disputes along the value chain, let's say, of the new space economy, which, as Laura has said, has grown even since we've been doing it exponentially, and there's been a big shift from, a continuing shift from kind of government state participation in a sector to private activity, private commercial activity, and the amount of private commercial activity now in the area is very large indeed, and that in turn, any increase of activity in any sector inevitably also results in an increase in disputes. We've also seen increasing amounts of advice needing to be given on investment treaty protection or avenues that might be able to be explored in the wake of kind of governmental action. And so we've had to advise on that too in the more recent years.
Thank you so much. What about you, Laura? What types of disputes in the space-related field you're already seeing in your practice, both in commercial or investment arbitration?
Yeah, I think as Rachel explained, I mean, the industry is growing. There are more and more actors that are entering the space sector, and there are many contractual relationships organizing all of these activities. So you see that there are disputes along, I mean, as Rachel said, the whole value chain. And then I think there's an additional component that is becoming more important, because I think we have all observed that there are like strong geopolitical shifts, and the space sector is part of that, and that we can see that for military conflicts around the world, the space component is becoming more and more important, and that provoked also a shift in the view governments are seeing the space sector. It's no longer seen as something like nice to have, but more and more as part of the critical infrastructure for governments. And so the national security aspect with regard to space activities is becoming more and more important. And that can lead to commercial or contractual disputes. For example, if export control regulations interfere with commercial relationships. But it also gives rise to more and more investment disputes, because governments, I mean, space investments obviously have a long investment horizon, but as the policies interfere with space regulation, we see that there are more investment disputes that arise in the sector. And most famously, most recently, the OneWeb case against Russia that was initiated last summer.
Okay, thank you so much. What you mentioned is very interesting, because it made me think that this is such a sensitive field, and our audience may wonder whether arbitration is the most suitable way to resolve space-related disputes. What is your view on that?
Well, both of us are biased arbitration practitioners, so take what we say with a pinch of salt. I mean, my experience from the clients that I represent in the sector is that when they are faced with a dispute, they want to resolve it in whatever way as quickly as possible, because, I mean, I guess with any industry, time is money, but especially in the space sector, there are often very tight deadlines. Launch windows need to be booked, in advance, and the lead times to get those have an impact on the service that can then ultimately be delivered, of course, by the satellites that are launched. And so everything is quite time pressured. And often when a client comes to you and with a dispute, they need to just find a quick, commercial, effective solution, and they don't really want to go down the arbitration route. They want to find a real, a practical solution for what they need to do there and then. That said, of course, luckily for us, not all disputes can be resolved via negotiation. So in that situation, arbitration, we find, is a really effective way of resolving the disputes, partly because it is, although it's a large industry, everyone kind of knows everyone, as in other industries. So these companies don't particularly want to air their laundry in public. They want to keep things behind closed doors, so the confidentiality aspect is really important to them. The enforceability, because lots of these transactions have almost always a cross-border element. The enforceability aspect is also the other really important part of the jigsaw, which I think clients can get from arbitration because of the reasons that we all know. So I think confidentiality and enforceability are the two kind of main pulls for clients in the space and satellite sector that I see. And all of the other normal attributes as well are well suited. Like you can choose arbitrators with technical expertise, etc. But I think the confidentiality and the enforceability are the main ones, to the extent that many companies use arbitration clauses as standard in their agreements. The European Space Agency uses arbitration clauses as standard in its agreements with its contractors. And I think it's a well-recognized form of dispute resolution within the sector, whether it's institutional arbitration or ad hoc arbitration, or there are some sort of standing ad hoc rules within, for example, the International Space Station Agreement has a kind of an ad hoc set of arbitration rules, which we might not recognize as, they're not what we use every day, but they're still arbitration. So it's a well-recognized and effective dispute resolution tool, in my humble opinion.
Thank you so much.
Yes, I think, there are a lot of international contracts in the space industry, and for all of the reasons that international arbitration is often chosen for international business. Obviously, that is also the case in the space industry. And based on the contracts that I have seen, most of them have ICC arbitration clauses, mostly with Paris as the arbitration seat, in part because the European Space Agency, which is an important anchor client for many space companies, is based there. But I just wanted to mention that there are the PCA outer space arbitration rules. So in 2011, the Permanent Court of Arbitration published specialized rules for the space sector. There are not yet any public disputes under these rules, but apparently they have been included in contracts already. And they are a good option. They're based on the UNCITRAL rules, but they have special provisions that are catering to the space industry, like, for example, a confidentiality advisor. And the PCA also has an arbitrator list for arbitrators with space experience. It's not completely updated, but I have been told that they're working on that. And the PCA obviously has also a lot of experience administering disputes, and especially if there is a government entity that is involved, that's definitely an option to consider, I would say.
You mentioned that the PCA special rules were adopted in 2011, and this made me think about the future forward-looking regulations. Do you think that given the increased private sector activities in the space industry nowadays, do you think the current international legal framework governing outer space is sufficient or not?
There are already several international treaties that were developed in the 60s and 70s, which are still important because they established the main principles of cooperation and activities in outer space. But as we are observing more and more space activities that were not foreseeable at the time when the treaties were concluded, we see that there are certain gaps. And one important gap, for example, relates to the extraction of resources in outer space. Because under international space law, space does not belong to any country and cannot be appropriated by any means. And so the question is, if space does not belong to anyone, can you go to the moon, for example, and extract resources, for example, for commercial purposes? The general view is that as long as you do not establish sovereign rights over the territory, maybe you could use the resources. But for example, to establish mining activities, you need to set up certain safety zones around those activities. And then the question is, how long can you, for example, reserve a zone until it becomes appropriation? Or could it be permanent, or how big could it be? So there are a lot of questions that will arise around those activities that I think are not yet completely settled. And similarly, for example, if you make inventions in space, for example, on the commercial space stations that are now being developed, which IP law will apply in space, and how can you register and enforce these rights are also interesting novel issues, I think, that have not been completely resolved yet.
And another one, just to add, is liability, because as everyone hears about in the newspapers, there's Starlink is increasing in size, its constellation all the time, and there's now other constellations from China, from Jeff Bezos, you know, right, and from, as we heard before, OneWeb. So low Earth orbit is becoming very, very congested, and at some point there may be a collision between satellites, and under the current international framework, liability is addressed, but there are some gaps, for example, to think of a better word, but there's some gaps in that framework which don't necessarily provide easy answers. So I think that will be another area, in addition to those that Laura has mentioned, that will be tested in the coming years.
And Rachel has a great proposal to resolve this, but I think she should say a few words about that.
Okay, well, I'll try and I'm conscious of time, but I mean, the first thing to do is to ascertain the profile of the dispute. We have state-to-state disputes, you know, but we have the ICJ and other mechanisms to resolve those. We've heard about mechanisms that we use day-to-day to resolve commercial and investment treaty disputes. But in the case, for example, of a satellite collision, that wouldn't necessarily fall under any of those. So it wouldn't be a state-to-state dispute or a commercial dispute or an investment dispute. And so at the moment, there's no dispute resolution mechanism in existence that would provide private actors with a recourse against a state. And it would be a private actor, for example, if you have a private satellite operator, of which there are many, you would have the recourse would have to be against the state, because states remain responsible for national activities in space. And you would have a substantive right, because if your spacecraft was damaged, because the space treaties that Laura mentioned do create a right for compensation for damage. So you would have a right, you would have a clear recourse against a state, but you wouldn't have any way in which to even try and pursue that right. So my suggestion is that that an ICSOD convention is established, an international convention on the settlement of outer space disputes, which essentially mirrors what ICSID did. ICSID was created in a kind of a similar era. There are lots of parallels, because at that time, you know, foreign investment was being made, and yet if a foreign investment was harmed by a host state, the private investor had no recourse apart from diplomatic channels via its own government. And in a similar way, in space now, we see private investors with potential claims against states, but zero recourse. So just as ICSID was established for those foreign investment disputes, I've proposed in a couple of different papers that the time is now ripe to create an ICSOD convention.
Thank you so much. Let's hope for the future of the ICSOD convention as great as the present of the ICSID convention. Thank you so much, both Laura and Rachel, for this insightful discussion. We will now move to the Q&A session, which is not recorded, but everyone can join and ask questions. And for all of those who watches us on YouTube, thank you so much. And until the next episode in 14 days. Thank you very much.
Thank you very much.
Thank you.
Thank you.